the civil rights case is considered the Civil Rights Act right to ban second places of public accommodation, and by a vote of 8-1. So the case that versus Section 5. Or immunity. Now, I mentioned this before, but over the Supreme Court had never really given the Second Amendment any thorough treatment. Now, I used to assign the case of district a well-regulated militia being necessary to the security of a free state, comma, the right of the people to keep and bear arms shall be infringed. And in Heller, the court held by a 5-4 vote that protects an individual right to keep a firearm in your home, and collective right as part of the militia. Okay. But the Second Amendment only applies directly to the federal government. In fact, the case D.C. v. Heller involved the federal government. Could the District of Columbia deprive you of the right to bear arms? Immediately after Heller was decided, this guy, Alan Gura, who was a lawyer in D.C., filed a follow-up lawsuit in Chicago. At the time, only 2 places in the country banned possession of pistols, handguns at home. The city of Chicago. Everywhere else you were allowed to have it with a license, but in Chicago and D.C. the handguns were banned. So immediately after it was decided, Gura filed a lawsuit. With Allen in another case, another Second Amendment case, which involves a 3D as we speak. Right? But Allen argued case. The question was, did the Second Amendment restrict Chicago? Right? Did it apply to Chicago? Now, the easy way to win this case was saying, yes, due process clause, right? That one of the liberty interests protected by the 14th Amendment is the Second Amendment. Therefore, incorporation. Allen, who was a very, very bright lawyer, argued an additional approach. He said that the right to bear arms is one of the privileged or immunities of citizenship. And they are now popular. They meant a very Kennedy on opinion other in the okay, this is, I'm actually concerned about his address. I mean, you know, as you know,
you should explain it to it. He just from your
what are courts which maybe means that
no, he doesn't.
Oh, he asked
those the other that you should meaning of
time which
I guess he's credit thinking enough to stand, although change is inevitable, the law should be assumed regardless of
Crystal. Why does trying to figure out what are these phrases, what are your communities understand this. Let's go to do this. Why?
He was trying to go almost to the song and stopped it.
Why is he so on figuring for 100?
That would have allowed him to use it.
Eric, why is he so upset with people making, you know, whatever?
They, you know, the decided as dissenting.
Right down Chicago. Right here. We're slowly getting to the answer. However, he should not be doing it based only on a sense of what's right and wrong. Maybe that happened not. I think Thomas feels some duty before he strikes down this law to give a reason why. And the rationale he gives is that this is not me, this is not my own personal preference. Agree with him or not, that's his reason. He says, when you look at how this phrase privileges or immunity was understood in the 1860s, it would have been understood to include the Bill of Rights, the First Eighth Amendment, including the Second Amendment. So the reason why he spends so much time digging through this history is, in his mind, that's what gives it legitimacy. That he's not doing this merely because he likes guns, but because in his mind, the phrase privileges or immunities embraces the Second Amendment. And then when a state tries to deprive someone of those rights, it is his responsibility as a judge to halt a law that abridges those rights. Right? This form of a constitutional interpretation, which is often called originalism, it's a general notion that judges interpret a constitution based on how its framers would have understood it. The competing approach, right, is what we might call living constitutionalism or something of that nature, which says we should interpret the phrase based on contemporary standards, regardless of how people in the 1860s understood guns. Today, maybe that's an antiquated notion. But Thomas's opinion isn't just about guns. He isn't simply saying, this gets you to strike down a handgun law, let's be done with it. His purpose is that this entire doctrine of cases, beginning with Slaughterhouse and Cruikshank, maybe Bradwell, I don't know if he would include that, is wrong.
I'm sorry, would you mind going back and restate the difference between the two types of interpretation?
How much time do you have? That's okay, I'll do it.
Sorry.
No, that's okay. So, there are two broad umbrellas of constitutional interpretation. One of which we call originalism, which is the notion that you should interpret a text to understand how it would have been understood at the time it was drafted. There are other strands of originalism that look at intent. What were the intent of the framers? We talked about that earlier today. Another broad umbrella, and I'm summarizing this in 1 minute, is what you might call living constitutionalism, which is the notion that you interpret the Constitution according to the circumstances of the day, and you should not be governed by the dead hand of the past. That is, if the Constitution was drafted by people who are long dead, they should not govern us. And invariably with this latter approach, judges are there to synthesize and figure out what the ideal rule is. These are things you can write about for the rest of your life and never come to a complete conclusion, so I won't even attempt to do it here. Justice on the court, I think now the most common originals, we'll see what Justice Gorsuch brings to bear. Evan?
What do you
It doesn't matter. Doesn't matter what but you need to be aware of all these views. You need to be aware of all these views. But given Thomas's, and we're running a little bit short of time, given Thomas's understanding of privileges or immunities, I don't have to. Actually, has he then defined the phrase privileges? Does he give it a fixed meaning, or has he approached it? Has he then?
The right.
Okay. Does Thomas agree with the slaughterhouse majority? Does Thomas agree with the slaughterhouse majority?
No.
Are you sure?
No. Yes, he does. I don't know.
How did the slaughterhouse majority define the rights of the Privilege and Immunities Clause? What do they define them as?
I'm thinking of the dissents.
I know you're thinking of the dissent, right? Does Thomas agree with the majority of the dissent? The privileges and immunities.
I think that he agrees with the dissent. He's talking about the Second Amendment and how that is a natural right, which is similar to what Field said, as far as ability to making a contract and things like that are also
Very good. Thomas agrees with the dissent in slaughterhouse, right? Thomas agrees with Field and others. What Thomas says is that to read slaughterhouse so naturally, right? A civil war was fought. It was meant to bestow a lot of rights on people from state infringement. And precisely because the communities had it, understood people, the organization of court, and that probably includes to Thomas the Civil Rights Act of 1966, the rights listed in Corfeld v. Coryell, and the first 8 amendments to the Bill of Rights. So because of that, he would overturn Slaughterhouse, he would overturn Cruikshank, doesn't mention Bradwell, not sure if he would actually, but he would overturn at least Cruikshank and Slaughterhouse, and give the Second Amendment to the 14th Amendment, incorporated. It would give effect to the Second Amendment. Right. As a result, because the Second Amendment applies to the states, and the city of Chicago had a complete ban on handguns, you couldn't get a license for one, he found that law was unconstitutional. So this was the last case, this heard argument in the Second Amendment case. It's been about a decade now at this point. I guess 7 or 8 years. Yeah, well, Jackson.
So when did the Bill of Rights start applying to the states?
The Supreme Court did it gradually over the course of maybe 50 or 60 years.
I know in this case they originally said they didn't apply to the states.
Well, in Barron v. Baltimore, right, Chief Justice Marshall said that the Bill of Rights don't apply to the states.
Right.
The court started incorporating in the early 20th century, and by the 1960s or 70s, they were more.
So now that the Second Amendment was
First time it came up, yeah. Yep, first time it came up. This. A lot of good stuff. What you'll see in class on Sunday, that back, and you recall that to enact civil rights legislation, they relied on the Commerce Clause. Why did Congress have to turn to the Commerce Clause to prevent discrimination? because of the civil rights cases. So the decisions of the Supreme Court in the 1870s and 1880s, which narrowly read the 14th Amendment, required a shift to other provisions of the Constitution to desegregate and to protect various rights. Anything else? No? I will see you all on Sunday. Please come. Thank you. Don't make me do this by myself. I think it's 2 o'clock. I'll check in 1 second. Yeah, 2 o'clock.
In this room or the one we were in?
4:14. 4:14. I'm sorry, I didn't plug in. So. See what happened was it was like this. It wasn't pushing all the way. So only the first 90 minutes that were captured.
Oh, that's still a good chunk.
Yeah. Yes, ma'am.
Reese is still acting crazy. I don't know what's going on.
Solving problems?
Yes, I couldn't even check in today.
All right, I'll mark.